Hello, everybody, and welcome to today's webinar. We are going to be talking about workers' rights in BC, and this is part one of a two-part webinar series. My name is Paula Price. I will be your moderator and host today, and we will be joined by our very special guests, lawyers Jessica Foreman and Jim Wu, both from Forte Workplace Law. Now, in terms of whether you are in the right place, if you've got questions about workers' rights in BC, you're absolutely in the right place. Today, we're going to be talking about your rights at work, including rights that many workers don't know about. We're also going to be talking about how to deal with your legal problems. What you can expect, we've got 60 minutes together, and our speakers will be providing answers to common questions. What they are sharing is legal information, not advice. Legal advice would be the law as it applies to your unique set of circumstances. And if that's what you're looking for, then we encourage you to reach out to a lawyer. You're welcome to contact one of our speakers. Their contact information is on the screen. And of course, the information they're sharing is current as of today's date. We would also like to acknowledge that we are grateful to work on the traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we encourage you to reflect on where it is that you are joining us from today. We'd like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes production of these webinars possible. And finally, we would love to introduce you to our speakers today. So we have two amazing lawyers, both of whom are return guest speakers who practice at Forte Workplace Law. We have Jessica Foreman, and Jessica is a lawyer and workplace investigator who practices exclusively in the areas of employment law and workplace and human rights. Jessica helps employees and employers avoid workplace conflicts, solve their workplace problems, and proceed with court actions when needed. Jessica also speaks regularly about workplace issues like harassment and workplace safety and facilitates Forte Workplace Law's stand-up teams workshops. One of Jessica's clients described her as, "We always know we're in good hands with Jessica, who seamlessly guides us through compliance, interpretation, and process with transparency and professionalism." And we are thrilled to have Jessica here with us today. Welcome, Jessica.
Thanks, Paula. I'm really excited to be here.
Thank you. And we also have Jim Wu. Jim Wu is also a lawyer with Forte Workplace Law who practices exclusively in employment law. Jim loves going to court to give his clients a voice and never backs down from challenges. Before becoming a lawyer, Jim worked as an employment insurance adjudicator and made decisions on thousands of EI claims, which experience has been incredibly valuable in advising clients about employment insurance matters and appeals, and in representing his clients before the courts and administrative tribunals. One of Jim's clients describes him as so clear, thorough, and knowledgeable, and answered every question, and I had a lot without hesitation. Jim, we are thrilled to have you here today. Welcome to today's webinar.
Thanks, Paula. I'm very thrilled to be here as well.
Wonderful. So our first question is for Jessica. Jessica, the question here is, what is the difference between being an employee and an independent contractor, and why does it matter?
Great. So I'm going to start off just with a comment that these terms, employee, independent contractor, or contractor, are often used interchangeably, right? Folks will say, oh, I'm a contractor, I'm an employee, without really understanding that there is legal significance to them. So that's the first thing I want people to understand, is that there is a legal difference between being an employee or being, and the whole phrase is independent contractor. Sometimes people shorten it and refer to it as a contractor. And the general concept is that an employee is somebody who works for an employer and is in turn is guaranteed certain protections by that employer and the law. So the Employment Standards Act here in BC, which you're going to hear Jim and I refer to quite a lot today, governs how employers and employees must deal with each other on certain issues. And so an employee is protected by all of the provisions in that act as it relates to wages and overtime and benefits. Alternatively, an independent contractor is seen as a more independent worker who does not solely work for one person or one employer, and therefore is not afforded all of the protections of the law. So an independent contractor is someone who can be we consider self-employed, like maybe a painter or a massage therapist or a plumber, someone who has a particular trade or skill and works for a number of different clients and really has control over that work. So I'm going to ask you, Paula, to go to the next slide where we've got a list of some of the factors that are considered. And this list is not exhaustive. There's a number of different factors, but these are some of the key ones that, we as lawyers, when someone comes to us and asks about their rights, and we're trying to determine, are you an employee or an independent contractor, we would look through. So things like, how much are you directed or controlled to do your work? Is an employer directing you to do particular tasks and particular hours to work? Or are you in control of your hours and which jobs you're going to do and how to work? Is it an ongoing relationship? Do you have a direct connection to the business? How many clients do you have? What's the risk? Are you directly connected to, if the business makes money, then you make money, or are you paid a salary regardless of how the business is doing? Other factors that aren't on this list include things like whether you pay your own taxes or whether your employer does, and whether you're provided certain benefits. Now, just a couple of misconceptions here is that you can call yourself an independent contractor or a contractor, and you may still be an employee under the law. So just because you've got that in your title doesn't necessarily mean you're not an employee. These factors are what really make the difference. So why does it matter? Other than what we call you, there's a number of reasons that it really does matter. And first of all, as I mentioned, if you're an employee and governed by the Employment Standards Act, then the minimum requirements around wages and benefits and overtime and pay for statutory holiday, for example, those all apply to you, and you're entitled to receive those protections. The other key reason that it matters, and this is where Jim and I probably get the most questions when clients call, is around termination pay. So when and if you are let go from your job, if you are an employee, you are entitled to minimum severance. And Jim's going to talk about that a bit later in our talk. If you're truly an independent contractor and you meet all of these requirements, then you are not entitled to that minimum notice. And you're only entitled to whatever the agreement between you and whoever you're providing the work does. So a brief example is that a contractor or a construction worker may have an agreement that says, I agree to work on this room in this house, and if you want to fire me, you just give me 2 weeks notice, or you tell me a month ahead, and that's the end of our relationship. And you as an independent contractor at that point would not be entitled to any additional severance or notice like an employee would be. So I'll leave it right there. The Employment Standards Act, or the branch, does have a lot of information and a similar list if you want to take a look at these factors. But the key to remember is that there is a legal difference in terms of how you're treated, both when you're working, what you're entitled to, and at the end of your employment.
Beautiful. Thank you, Jessica. And this infographic comes from the People's Law School website. So if anybody would like to have a closer look at that, you'll find it on our web pages, and we'll put a link to it in the notes that come along with the recording. This next question is for you, Jim. I wonder if my employer is cutting corners when it comes to pay, including overtime and leaves. How do I know what I'm entitled to?
Well, I'll answer the latter half of your question first, Paul, which is how do I know what I'm entitled to? So this is where I ask all the attendees to grab a pencil and pen, because I'm going to be blasting you with a lot of information that's very useful and handy. So in BC, an employee is said to have worked overtime when either the employee has worked more than 8 hours on a given day, or when that employee's worked more than 40 hours in a given week, or is scheduled to work on a stat holiday. So these are three different conditions where you could be set to work overtime. We have a daily overtime rate, which is anything past 8 hours a day is subject to overtime. And then there's a weekly overtime, which is any hours you work in a given week that's over 40 hours. That's also subject to overtime. And if you happen to work on a statutory holiday, that's also subject to overtime pay. Now, keep in mind we have, I believe, a total of 10 statutory holidays in a year, and the best way to keep in mind, keep in track of what all of those holidays are is, I think I have a bit of a trick in my mind where every month there's a stat holiday, except for the toss-up is somewhere there's no stat holiday in June, and in March and April it's a toss-up of when Good Friday is scheduled. So keep in mind you have one statutory holiday almost in every month, and that statutory holiday is the day where if you don't have that day paid to you and you don't get that day off, then and you're asked to work that day, then the entire time that you're working on that stat holiday day, you are given overtime pay. So how overtime pay works is you're paid at 1.5 the hourly pay for any hours worked past 40 hours a week. But here's the catch: if it's a daily overtime, then it works like this. Anything past 8 hours, you are paid 1.5. But anything past 12 hours, you're paid at double. So the best way to tally up all of your overtime is, I would say, like, have a sheet of paper, and then for every week, tally up all of the hours that you worked, and actually break it down into days. So for, let's say we work 5 days a week, and just have a day 1, day 2, day 3, etc. And for each one of those days, tally up how many hours you worked. For any hours of those days that are in excess of 8 hours, mark that because you are subject to overtime pay. And then add up the numbers and find out anything that's over 40 hours, you get the overtime pay, and any of those days which are more than 8 hours, you'll also get overtime pay as well. And how do you actually comparing to see if your employer might be cutting corners? Well, the best way to find out, if we can go to the next slide, Paula, is by looking at your pay stubs. Now, this is an example I got off the internet. I don't really know who this rubber cleaning service is. But for example, over here, they have all of the hours which this individual has worked. And you have where the rate is $18 per hour. Looks like this person's worked a total of 80 hours for that period. And how you take a look at this is when you look at the pay period, which is the second column above, you will note that it has from the period from March 15th to March 31st. So this person is paid on a semi-monthly period. So what you do is you look at that pay stub to see whether the hours all add up, and you can do that by either keeping track of your hours, or if your employer has a punch in punch out mechanism, look at those and see whether those add together. The numbers should really equal to what's on there. Anything that's over the 80 hours, I would flag that as possible overtime pay. And on the pay stubs, there should be a section where it says anything past that, it should be labeled as overtime pay, and that should be paid to you at either 1.5 times the rate, or 2.0 if you happen to work over 12 hours. The other thing to keep in mind is that takes care of the overtime piece. Now, about leaves, there are two types of paid leave in BC. You have your sick leave, which you have 5 paid days every year. And then you have your vacation, which is only paid to you if you don't get any vacation pay. So if you looking at this particular example here, there isn't a vacation pay section. So this person is entitled to paid vacation. And how it works is, under the law, in your first year, you actually get no vacation. BC is actually the only province in all of Canada that actually does not give any of its employees any vacation in their first year. But in their second year, to the end of your 4th year, you get a total of 2 weeks or 10 working days. And in your starting from your 5th year, you get 3 weeks, which is you get a total of 15 weeks, 15 days off, and those are paid days. And the best way to keep a track of them is to make sure you mark them on your calendar. And there should also be a section in your pay stubs that tell you how many days of vacation you have left. This particular one does not have that over here, but typically they will indicate that, as well as how much paid sick leave you have left in your what they call your bank. So that's the best way to keep a track of how many hours of overtime you worked, how many days of paid sick leave or vacation you have left, and it's the best way to make sure that your employer is not trying to cut corners when it comes to what your entitlements are.
Great. Thank you, Jim. And I gather this information is all available on the Employment Standards website.
Yeah.
Excellent. And we'll provide a link to that along with the recording of today's session. This next question is for you, Jessica. I suffer from depression and anxiety, but I'm still able to work. Do I need to tell my employer about my mental health condition?
Great. So the short answer is no. If you are able to perform your work and fulfill whatever the obligations are of your employment agreement or the understanding and expectations, then you are not required to disclose any of that private information about your health at all to your employer. If, however, any condition, whether it's a mental condition like depression and anxiety, or a physical condition like you've been in an accident, or you have a sore back, or you have a heart condition, or anything else, if any of those things are in fact impacting your ability to work, that's then when you're not, legally required to, other than if you're going to miss work, you have to provide a doctor's note. But we recommend that you have those conversations so that your employer can make changes and take steps to accommodate you to ensure that you continue to work and you can continue to have a job to go to. So an employer is not entitled to pry into private medical information for you unless there's something that they need for you to perform your job. So, for example, if you are taking medication that might impact your ability to do a certain task, like operate equipment, for example, then you need to tell them. Or if you need to leave work early to attend an appointment or see a therapist, you do need to provide a medical note for any of that time away from work. But if you want to voluntarily choose to disclose additional information, you can do that. But know that just because you decide to share some information does not mean that then the employer is entitled to learn everything about your condition or your health or your mental condition at all and sort of ask prying questions. So it is up to you to make that decision. It's not required unless it's having a direct impact on your ability to continue to do your work in the way that you're expected to do it.
Perfect. Thank you so much, Jessica. Jim, this next question is for you. I work for a company painting houses. I worry sometimes that I'll injure myself on the job. What responsibility does my employer have to keep me safe? And would it be different if I was a contractor instead of an employee?
So your employer has the responsibility to make sure that you have all the tools and environment necessary to keep yourself physically and mentally safe on the job. And that includes providing you with the necessary equipment for you to decrease the likelihood of any sort of injuries occurring in the workplace. And in terms of whether it will be different, whether you're a contractor as an employee, in theory, the short answer is, well, as you would ask every lawyer, it would depend on the circumstances. But in this case here, the best way to determine that is to see who actually pays for your WCB premiums. There's a lot of arrangements where it's an independent contractor, but the employer or not the employer, the person that's hiring the independent contractor's services still pays for the WCB, and in that case, it's a pretty good indicator that it's still the person who hires the contractors who's liable for the WCB component. If you've been asked to pay for your own WCB premiums, you have a responsibility to make sure that you are safe as well. Ultimately, there's an overarching requirement for whoever's governing the workplace to make sure that their employees are their employees or their service providers are working in a setting that's safe and that they've taken all measures to minimize any likelihood of danger arising. I will add that if there's anything in addition to what an employer or an employer is expected to provide, that does require the person to maybe raise that to the person's attention. So if you are, let's say, if you're particularly scared of heights and you need some additional measures to be able to, for you to do that job effectively, then you would need to let your employer know, because otherwise it's not really reasonably expected that they would know this. And the only way for you to ensure that the work goes safe is always through communication and through dialogue.
Super. Thank you so much, Jim. Another question for you, Jim, which is, I'm an employee who works from my home office. I have trouble sitting at my computer all day and have heard that a standing desk could help. Is my employer required to pay for something like that?
Right, so this is what we call, there's a duty for accommodations. Now, the duty for accommodations doesn't necessarily mean, employer, I have difficulties sitting at my desk. I insist you buy me the desk in the world, one that allows me to, gives me all the perks. It doesn't work that way. It's a dialogue where ultimately everyone has to make a compromise. In this case here, you would need to engage in a dialogue with your employer, basically setting out, okay, this is, I've been noticing that I've have some difficulties sort of sitting, and I tried I tried switching chairs, I tried other means to basically see if that works. It doesn't, and it's gone to the point where I went to see the doctor. My doctor even recommends that I get some alternative arrangements when it comes to work. Through my doctor's advice, I heard that a standing desk could help me get through work, and I was wondering if this is something that perhaps we can make some sort of a whether it's something that the company is able to help me out here, because I've taken a look at some of the pricing and they're fairly pricey, and it's not really one I could afford. So any accommodations, any contributions will be really welcome, and you set it out nicely and tell the employer how much you love working there, and hopefully that'll get you your standing desk.
Super. Thanks so much, Jim. I appreciate your practical suggestions in terms of how you might approach a problem like that. Jessica, this next question is for you. I've given a lot of personal information to my employer, including my social insurance number, home address, and even some sensitive information about my family. Is my employer required by law to protect my private information?
And again, the short answer to this one is yes. Private and personal information is governed in British Columbia by the BC Office of Information and Privacy Commissioner. And they've got really, really helpful resources. Anybody who's got questions about privacy, I encourage you to go look there. I use it all the time when I'm advising clients in this area. So I'll just put a plug there for the Office of Privacy, and I see that's in the chat. Great. So there's two different statutes that govern privacy. One is it's called FIPPA, F-I-P-P-A, which is the Freedom of Information and Privacy Act. And the other one is PIPA, P-I-P-A. And they govern whether it's public institutions, that's for FIPPA, or whether it's private institutions for PIPA. Regardless of which one, they both set out general rules about what an employer can and can't do, or businesses and organizations can and can't do with your personal information. And the idea of personal information is that it includes any information that is identifiable about an individual. So things like a name, an address, a health number, a social insurance number. Those are very clearly personal information that falls within these statutes. And there's rules about when an employer or a business can and can't use them. So if an employer does disclose them or share them without your consent, that would be a breach of those laws, and that could be actionable. Now, it's very important to remember, though, that consent is a way that an employer can share that information. And we all get, lots and lots of emails when we're signing up for things or agreeing online to things. Do you consent to the disclosure of your personal information? So similarly, an employer may ask that of you when you are hired or at any time during your employment. So if it's something you're concerned about, I would encourage you to pay attention to those requests and make sure that you're informed before you give that consent. Because once you've given it, then the employer is allowed to disclose and use that information. There's limits to how they can do it, but it's much more difficult at that point for you to then raise an objection and say, I didn't agree to it. But as a general rule, any identifying personal information must be protected unless you give consent to an employer or a business to use it or disclose it.
Thank you very much, Jessica. Jim, this next question is for you. I was recently fired from my job. My employer gave me 3 weeks notice with the choice of working notice or getting paid a lump sum. How do I know if 3 weeks is enough? Is it better for me to take the money as a lump sum or work through the notice period? And what if I get another job during that period?
So in Canada, every employee is entitled to reasonable notice of termination. And reasonable notice has two components. There's first a mandatory minimum component, and there's also the possibility of additional severance. So I'll talk a bit about the mandatory component because that part you don't necessarily have to have to go see a lawyer. It's pretty easy for you to figure out. And the mandatory minimum component is found under the Employment Standards Act, which basically has ranges from 0 to 8, and how you determine how much of that range you get is entirely dependent on how long you've worked at that particular organization. So if you worked for 3 months or less, you get nothing. If you worked over 3 months to a year, you get 1 week. If you worked over a year to no more than 3 years, then you get 2 weeks. And then after 3 years, you will get 3 weeks of pay plus an additional weeks of notice for every subsequent year, but up to a maximum of 8 weeks. So in other words, if I can summarize it, the lowest you can get is nothing. The highest you can get is 8 weeks when it comes to the mandatory minimum component. The possibility of additional severance, that piece, you would definitely need a lawyer to work that through because there's so many factors at play here. But ultimately, the range for that can go as low as 2 months to as high as 24 months. So it is quite a substantial amount of severance and money at play here. And the reason why you had to have a lawyer take a look at it is there's so many different factors, including whether you have an employment contract, whether that employment contract is enforceable, and what does that employment contract say about your termination rights with respect to the additional severance piece. In terms of whether it's better to take the money as a lump sum or work through the notice period, the difference between a lump sum and a notice period is with a lump sum is you get the money right away, and the notice period means that I basically give you notice and you still have to work through that notice in order to get paid. It actually does link into the next question, which is what if I get another job during that period? And this is where if you have a lump sum payment, that money is yours, and even if you start that job the following day, you still get to keep those monies. The mandatory minimum component is not subject to any duty to mitigate, and what that means in legalese is that if you find a job the next day after you receive those monies are still yours. But the practical reality is if you were to, let's say, work the notice period instead of getting the money as a lump sum, then you're kind of put in a practical bit of a dilemma where you have two jobs out there for you, but you can only really be working at one. So I know we're not supposed to give any advice, but for practical reasons, it may be better for a lot of reasons just to get the money as a lump sum. It's just more practical and leaves some more options open. Someone had in the Q&A asked a question about EI relating to ROEs and timing for EI applications. So when I worked as an adjudicator, what we always tell employees when they're out of a job is apply right away. Don't worry about the ROE. The ROE is not your responsibility. That's the responsibility of your employer to issue. All you have to make sure is you put in an EI application as soon as possible. The rules say within 28 days after after you're out of a job, and the reason for that is anything past those 28 days, you could be at a loss for benefits. In terms of how it will affect your severance, the rule is very simple. You cannot collect EI and severance at the same time. And if you are in a situation where you're getting EI and severance at the same time, what will happen to your EI is it will just get adjusted. Either you will need to pay back some of the EI that you received that corresponds to your severance period. So what I mean for that is, let's say you get 2 months of severance and you collect EI for 2 months, then those 2 months of EI will need to be paid back. Or if you're still on an active EI claim, then what will happen is, and you're still out of a job, is those 2 months will basically get pushed back. And if you still, let's say in the next 2 months, remain unemployed, then you potentially can get 2 months of EI pushed back later, and you won't have to pay any of it back to the government. I know the latter part is a little bit complicated, but that's generally sort of what I tell clients when it comes to any sort of information they need to know about EI and severance.
Excellent. Thank you very much, Jim. This next question is for you, Jessica. My employer fired me. Oh, sorry. No, that's right. My employer fired me and offered me a severance package that includes an agreement to not work for any of their competitors in Vancouver. I'm a computer programmer, and comparable jobs are far and few between outside of Vancouver. Can they force me to sign it?
So this question involves a legal concept that is called restrictive covenants, and that's the legal term. And that term encompasses things like a non-compete or non-competition agreement, non-solicitation, or confidentiality agreement. And all of these things are what we call post-employment obligations. So it's when an employer tries to impose things on an employee or a worker that are going to come into play after you're done working for them, right? So that's what the concept, I just want to clear that up, that a restrictive covenant or these post-employment obligations, they're obligations that are being put on you after you're done working for them. So the general rule of thumb is that typically these are not enforceable, and they're only enforceable in certain narrow situations. So in the situation before you where it's part of a severance package, if you are receiving a severance like what Jim was talking about that goes above and beyond your minimum, and you've talked with a lawyer and you have negotiated something significantly more, that might be a situation where in exchange for receiving a substantial amount of money, you agree to be bound by these limitations and say, okay, I'm going to be paid 6 months severance. I won't work for a competitor for 6 months. That's something that you would be voluntarily agreeing to at that point. Because alternatively, in order for these restrictive covenants to be enforceable, they need to be clearly a part of your employment agreement at the outset, and they need to be drafted in a way that is very narrowly tailored. The courts do not like to prevent people from being able to work. So that's why we start from a position that these kinds of covenants are generally unenforceable unless they are narrowly tailored, they're very limited, and you've agreed to them up front. So the language has to be clear. There's a bunch of tests around this, but the rule of thumb that I often tell clients is do you understand what your obligations are when you leave? Do you understand what you can and can't do? And if not, they're probably going to be unenforceable. So, in this situation, again, there are times when you may be willing to agree to be limited by a non-compete in exchange for a significant amount of money. But that's something that I would strongly encourage you to talk with a lawyer about to make sure that you fully understand what you're limited to doing. Because if you breach that non-compete, let's say you ignore it and you go out the next week after signing it and you start working for a competitor, you might be sued by your former employer. You might have to pay back the settlement, and you also could be liable for further damages. So it is a significant risk to breach a non-compete if it's enforceable.
Wonderful. Thank you so much, Jessica. It's really helpful. This next question is also for you, Jessica. I've decided to tell my boss about my mental health condition and ask for a leave of absence. What are some tips for having a difficult conversation with them?
So now we're moving out of sort of the strict legal advice to how we advise you to deal with problems at work. And these aren't specifically turning on the law or legal issues, but they do have some legal implications to them. So Jim and I often have clients, that do ask for our advice on these kinds of questions. So I think it's great that we're talking about them. So my advice here is, if you decide to voluntarily share information and ask for a leave of absence, the first thing is to make sure that you're doing this at a time and a place that works for you when you feel safe and calm to have the conversation. I don't advise having these conversations in the heat of the moment. Maybe you're frustrated by something and you throw your hands up and say, that's it, I can't take this anymore, I'm going on a leave of absence. Or you've just received a really difficult performance review and in response say, you're adding to my anxiety or my stress. Those are not going to be productive conversations. So choose a time and a place to have it that you feel safe and comfortable. Consider your privacy. What time of day do you want to have it? Do you want to have it in a room where lots of your employees or other coworkers are walking by and wondering what's going on? Do you want to have it, in private? Who do you want to have the conversation with, right? Do you want to have it with HR? Do you want to have it with your direct manager? And make a plan about what you want to say and what you want to get out of the conversation. What are the key takeaways? Do you want to be off for 6 months? And do you want to have certain benefits in place? Do you want to have a gradual return? What do you want to get out of it? Write those thoughts down and go in with a plan. If you have medical advice from a doctor where a doctor has already said you need 6 months off, come in with that information. Be ready to share that information. And then the last thing I would say is think about what, if anything, you want to have communicated to your colleagues about your leave of absence. Your employer doesn't have to consider that, but if you come at it respectfully and say, you know what, I don't want it to be shared that I'm on a medical leave, I just want it to be shared that I'm on a leave of absence. Then, in my experience in talking with employers who are reasonable, they'll usually take that into consideration and work with you to message things in a way that will work for you.
Excellent. Those are really practical suggestions, Jessica. Thank you. This next question is for you, Jim. I looked into my wages and it turns out that my employer hasn't been paying adequate overtime. I think a letter would be the best way to put the information together. What tips do you have for writing it?
So we have included a sample letter, which,
Should I turn to that now?
yep, by all
Okay.
means. So the tips we have are as follows. Number one, make sure you provide the necessary details, including when you worked, how many hours you worked, and how much you've been paid, and how much is owing. Those are the key details management needs to decide whether, number one, you're entitled to the overtime pay, and how much. Step two, make sure you're non-confrontational and that you're forgiving. It's very common for employers to forget to pay their employees overtime, and just because they've forgotten to do so doesn't mean that they're not willing to do so, or that a reminder a reminder will definitely be helpful in the circumstances. Make sure you give them a deadline. so that way you'll be accountable, and make sure you follow up. I would add one more, which is probably have a figure in mind that you're willing to compromise at. I know that this is sort of black letter law and that this is your minimum entitlements, you're fully entitled to all those, but the practical realities are, um, your boss kind of holds your makes the decision to see whether you still have a job at the end of the day. You don't necessarily want to walk on eggshells to necessarily put you out of a job. That's the first sort of practical reality. And the other piece is, uh, we also do advise businesses, and the takeaway I get from a lot of business when it comes to why they're so unwilling to pay their employees overtime is they feel sort of the sense that, well, I never approved of that overtime from the beginning. I mean, it doesn't matter if you didn't approve it, you have the obligation to make sure that your employee does not work the overtime, but they do feel that that's a bit of a unfair and on their part. And for the employee, really you have two choices of whether one is to basically fight this to the very end and get every cent that you've worked, um, which can be emotionally and financially draining, or number two, basically have a figure in mind which you're willing to compromise and be happy to accept. Because at the end of the day, your employment, it's a relationship that's it's longitudinal, it's something that's should be long term, and you should really be focused more on sort of what your long term goals are rather than any short term gains.
Super. Thanks so much, Jim. And I appreciate your suggestion to give your employer the benefit of the doubt that they may have simply just missed paying the overtime. And of course, having an open dialogue about it is helpful for that long-term relationship, as you've described. Jessica, this next question is for you. I've tried talking to my employer about feeling harassed at work by a coworker. They're not taking my concerns seriously, and I want to make a formal complaint. What options do I have?
So, WorkSafe requires every employer to have a respectful workplace policy or a bullying and harassment policy. They're required by law. Okay. And that's going to be the first place that you're going to want to look in order to guide you for a formal complaint, because that policy by law not only has to say bullying and harassment is not allowed in the workplace and define those terms, but it also needs to have a complaint process. What do you do if you are being bullied or harassed or discriminated against? So that's the first thing. And if you can't find one or your employer doesn't have one option is to reach out to WorkSafe and to file a complaint with respect to their failure to keep the workplace safe by having the proper policies. That's separate, and that's not going to address your particular complaint, but that is something to keep in mind. So hopefully you open up your policy and it has a very clear guideline, sometimes a form to fill out to tell you what to do with it if you have a complaint. It typically involves submitting something in writing where you detail as much as you can what happened, when it happened, how you felt, who may have seen it, and then you submit that. If there isn't a form, if you don't want to write it down, organizations often have a phone line, a whistleblower line, or the option for you to go in and meet with someone and talk with them directly and tell them. As somebody who conducts workplace investigations, I can tell you that employers will more often than not encourage you to put it in writing. So if you can do that, that's the best option. At that point, the formal investigation process that's hopefully set out in the policy will then take place. And that can be done internally by somebody in your organization, or sometimes they'll hire someone like me or one of my colleagues to come in and conduct an investigation externally. That involves somebody talking to you, getting more details, getting more information, and then talking to the other folks that are involved in getting their side of the story. At the end of the day, all of the information is considered and a decision is made. Typically, there's an investigation report and a determination is made about what happened and if there was a breach of the policy. I'll just say a couple of things about this whole process for now, which is that it can take a long time. It can be very stressful, and it doesn't always resolve the workplace conflict. So if you are open to a mediation, conflict coaching, having a neutral discussion with an outside person. I really, really encourage you to consider those. It's not always appropriate in every situation, but in terms of you as the complainant feeling heard and feeling like your issues are being taken care of, sometimes those other informal processes can be much more satisfying than a formal investigation.
Thank you so much, Jessica. This next question is for you, Jim, and then we're going to turn to some of our live questions. What can I expect if I make a complaint to the Employment Standards Branch?
All right. So we could probably just piggyback on the last question, which is you wrote a letter to your employer, and the employer's response is, we have no overtime pay, period, and you're not getting a single cent of it. Um, in that case, one of the recourses is you make a complaint to the Employment Standards Branch. Typically, from my experience, it takes about a year for anything to happen. And what will happen is, um, an officer from the Employment Standards Branch will get in contact with both you and your employer and basically explain the process, which involves, first, there is an informational piece. So let's say the issue is overtime. Um, the officer will likely tell you, well, you're entitled to the overtime pay, but that's the overarching rule. There's some sort of exceptions to all this, like, are you a manager? Basically go through a few checklists to basically tell you that this is a law, but there's a likelihood you might need to make a compromise in the end because it's not as black and white as you think it is. And then they will also have sort of a similar discussion with the employer, basically saying, yes, you don't have an overtime policy, but it's a law that everyone gets overtime pay here. And yes, maybe this employee did not work the overtime hours as you had authorized them. And yeah, maybe they're even working behind your backs, but that doesn't mean that they actually did the job, and it still means you have to pay for all that. So they will go back and forth to initiate the first step, which is they try to have the parties mediate and come to a resolution. So that's the first step that involves, when it comes to governments, and it can take as long as a few days to up to maybe a month or even longer, depending on how complex the situation is. If that doesn't resolve, then the next step is they will start the investigation. And usually for the employer, that means they're going to be asking for a whole bunch of records for the employee. For the employees end, they might also ask for similar documentation. So going back to that overtime example, that's where having the letter, having the punch out, punch in timesheets really help, because that's sort of the evidence you provide to the branch in terms of your claim. And then they will look at all of this evidence, and then the officer will write an official investigation report. That investigation report will then be sent over to another officer who then makes a determination from looking at the report. And that's really a decision as to whether this claim is whether this claim has teeth. If it has teeth, then basically they would look to see what are the issue and determine whether any of these issues have been proven. I would say that the process is it is pro-employee, because you're looking at the enforcement of minimal rights. It's also benefits conferring, meaning if they will do what they can to make sure that the employee's claim is to basically process the employee's claim. In other words, if you have a valid claim that you have the overtime hours, generally speaking, you're in a good situation to probably get your claim substantiated, meaning that whatever you claim will likely be the number in the end, provided that it's proven by the facts. Now, once that's been done, this is where it gets really fun and interesting. The determination is made, the employer has to pay unless they decide to embark on an appeal. And if they do embark on an appeal, then that could make the process drag on further. But the one good thing about employment standards is, because it's initiated by the government, the collection of the monies that were made by the determination, the employee doesn't have to worry about that. It's the government basically takes it as part of their responsibility to collect those monies for the employee. So once a determination has been met, there's a pretty good chance that those monies will be collected and that the employee will get it at the end. The trade-off is it does take quite a bit of time. You're looking at minimum of 1 year to probably, there's no really sort of cap as to how long it could otherwise takes. And the government is also very busy because they get these claims on a very daily basis.
Excellent. Thank you so much, Jim. I'm going to turn us to the live questions, or the questions that came in today. And I noticed a lot of them were responded to in writing by our team. Thank you. And just to let everybody know, we will focus today on the questions that are most related to what we've just discussed. And there will be another opportunity for responses to these questions on May 14th. So I'm going to start with this question about overtime, Jim, which is the 1.5 overtime pay in addition to regular pay? So regular pay plus the 1.5, or is it just 1.5 total?
It will be whatever amount is in excess. So I'll give you an example. Let's say you work 9 hours. So you get your 8 hours paid at regular time, and then the one additional hour will be paid at time and a half.
Excellent. Thank you for clarifying. Jessica, there's another question here that I think ties back to the employee independent contractor discussion. Can an employer ask you to provide your own computer, copiers, phone, etc., i.e. office equipment, to fulfill an office position, or are they responsible for providing applicable equipment to do your job?
Right. They are required to provide you with the equipment that's necessary to do what they're asking you to do. So if they need you to work on a computer and print things, then they should be providing that to you. If you have specific specifications or requirements or prefer a scanner as opposed to a printer, that may be something that you're required to buy on your own time. But part of being an employer is in that employer-employee relationship is that they need to provide you with the tools in order to do your job.
Excellent. Thank you. Another question about overtime. I'll turn this one to Jim. It's got lots of upvotes. Is it legal for an employer to declare that they do not pay overtime, but continually request overtime hours, and when questioned, state that the employee can take the equivalent hours, not at 1.5 times, another day?
So the general answer is no. Employers must pay overtime, period. There is a carve out whereby if the employer or with the employee's written consent, then they could arrange something called a variance, whereby instead of getting the overtime paid to them, they can get it banked and take it as excess vacation.
Excellent. Thank you. Another question for you, Jessica. Can my employer force me to attend training if they feel it is necessary? I beg to differ. I told them I did not want to do it, but they kept harassing me about it. What should I do without breaking the relationship?
So, I mean, the short answer is probably they can, as long as it is somehow connected or related to your job. I mean, if it's training that has nothing to do with anything that you're doing, then I think you would have a stronger argument to say no, thank you. But yes, an employer can require you. They have to pay you for it, or make sure you're compensated for that time. And, I would suggest that if you're concerned about it, that you raise those concerns in a respectful way. But if at the end of the day, they think it's important in order for you to continue to do your job effectively, then that can be something that you're required to attend.
Excellent. Thank you. Another question here, and I think this may be our last, we might have time for two more. Again, receiving a number of upvotes. Is notice required, and how much, when an employer informs needing to reduce your hours, for example, reducing 35 hours a week to 28 hours a week?
As far as as far as I'm aware, there isn't really a magical sort of a precise legal answer I can give in terms of the actual how much notice they have to give to the employee. In terms of just like hours reduction, usually what I say to businesses is give it to them at least in accordance with the employment standards. So if this person's been working for a long time, let's say over a decade, give them at least 8 weeks beforehand for them before you make that change. It just shows that you're being respectful and that they also get to have their say in the matter as well. Jessica,
Yeah, I
what are
think
your
that that's
thoughts?
great. I think that's great advice. I would just add that this issue of a reduction in hours calls into it's the issue, the idea of a constructive dismissal, which is that, if you're unilaterally changing hours without agreement or without the proper notice, like what Jim just said, then that can amount to a constructive dismissal. So it's a tricky situation. It's hard to sort of answer with a pinpoint, but I think Jim's rule of thumb is a good guide.
Beautiful. And thank you both so much for all of your responses. And thank you to everybody who has submitted questions to us here today. As I mentioned, there will be a follow-up webinar with Jessica, with Jim, and we will be diving into the questions that you brought to us, the questions today, and also questions that you may submit to us prior to the upcoming webinar. So the other couple of things that I'll mention is that the People's Law School website has a number of really helpful resource pages on the website related to work. And so there's a link to that on the screen here. I highly encourage you to check that out if you have questions about any of these topics that we've covered today. There are also wonderful resources on the Forte Workplace Law website. There's a link to that as well. And finally, if you have a question that you would love to have an answer to, I would encourage you to reach out and use our Beagle chatbot. So you'll see what that looks like on this closing screen. If you look at the bottom right-hand corner, there's a little icon powered by GPT. You can actually go and use that and ask your question. And our Beagle chatbot is a chatbot powered by ChatGPT, and it's trained to answer your legal questions using information on the People's Law School and related websites. And so highly encourage you to check that out. We've been receiving some really positive feedback about Beagle, who we've been very busy training. So we have maybe a couple minutes before we're going to sign off. So I'll just turn back to our speakers and ask if there's anything that you'd like to share that we didn't cover today. So starting with you, Jessica, is there anything that you'd like to share with our guests that we maybe came out of today's discussion that you'd like to leave them off with?
Not not particularly. I was taking a quick look at the responses being generated by People's Law School. They're excellent and thorough. So there was some great content there. And look, my big takeaway, and when I'm advising employees, is having respectful, upfront conversations with employers when you've got questions is always the great way to start. And I know not everybody is able to do that or works in a place that is that way. But if you are, often you can avoid conflict by just asking questions and being respectful and having those conversations. So I encourage everybody to start there.
Beautiful. Thank you so much, Jessica. And thank you again for presenting today. Jim, is there anything that you would like to share with our guests before we sign off today?
I'd just like to echo my colleague Jessica's remarks. Like as much as I love being in court and resolving disputes there, I call trial basically the lobotomy of law, basically where if all else fails, this is the only hope left for you to do it. But please consider all other alternatives before you make that decision.
Beautiful. Such wonderful sage wisdom to be sharing with all of us. Thank you so much. And so excited to have you both back. So everyone who has joined us here today, thank you again for joining us. We will be back with Jim and Jessica on May 14th. We'll be diving into these questions and more. So please join us then. If you haven't already registered, you'll receive an invitation to do so by email. We would absolutely love to see you there. So thank you again, Jim. Thank you again, Jessica. Thank you to everybody who joined us, and we'll look forward to seeing you again next month.